Welcome to the National Crime Victim Law Institute's online toolkit video on a crime victim's attorney's notice of appearance. In this short video, we're going to talk about an important document that should be filed upon entering a criminal case on behalf of your client. We'll cover the purposes for this notice, and we'll walk through the contents of a sample notice of appearance. Now, why file this document? It serves three main purposes. First, it puts the court and the parties on notice that this crime victim is represented by counsel. Among other things, this should trigger the ethical obligation for defense attorneys and prosecutors, as well as their agents, to not communicate with the crime victim outside of your presence or without your permission. Second, it puts the court and the parties on notice that this crime victim intends to assert his or her rights. As we will discuss shortly, a notice of appearance should also include an assertion of the victim's rights, and filing the notice to formally assert the rights is important because many victims' rights are not automatically afforded and may require no further action by others until the victim requests those rights. Those rights often include the right to receive notice of certain events or proceedings, and they often have the clause "upon request" or something similar included in the wording of the relevant rights provisions. And lastly, the filing of a notice of appearance should alert the courts and the parties to add you to the service list for all of the filings and court notices in the case. While filing a notice of appearance can help to ensure that you will be included on the service list, it can't guarantee that the parties or the court will always include you on the service list. So be sure to double check the docket regularly for updates. A jurisdiction may have laws that explicitly mention this procedure. For example, Arizona has a statute that provides, on the filing of a notice of appearance and if present, counsel for the victim shall be included in all bench conferences and in chambers meetings and sessions with the trial court that directly involve a victim's rights. If you happen to practice in a jurisdiction that does not have such an explicit provision, and you encounter resistance to the filing of a notice of appearance, take a look at the case United States v. Mahan. It's a district court case from the District of Arizona, and it contains some useful language. There, the court found that the method chosen by the victim's counsel, the filing of a notice of appearance, was a reasonable procedure for ensuring the protection of the victim's rights under the Crime Victims' Rights Act. And please contact NCVLI for technical assistance. On the next few pages, or next few screens, we're going to walk through a sample notice of appearance for a federal court. Now, state notices should be similar with regard to content, although the format may vary depending on the local rules. And before we begin, if you wish to follow along with a printed hard copy of the sample notice of appearance, you can pause this video recording, go to NCVLI's online toolkit pages, and download a copy of the notice of appearance and come back. In this sample, we've highlighted the areas where you need to personalize for a particular case, as well as areas where we have a note to the practitioner. And one key area that I want to flag for your attention on this first page are the references to footnote 1. Footnote 1 is intended to remind practitioners to use a pseudonym to protect your client's identity. Now on this next screen, we have a snapshot of footnote 1. You don't need to read this footnote in detail right now, but just know that this footnote is designed to remind you that in all cases involving child victims, and in some cases involving adult victims, for example, sexual assault victims and trafficking victims, the use of a pseudonym in all of the public documents is a really important tool that you should utilize to help protect the victim's privacy. Here we've included a handful of case examples and statutes that support the use of pseudonyms to protect crime victims. We've also included a citation to NCVLI's bulletin on the use of pseudonyms in civil cases, which is available for download on our website. While this bulletin specifically addresses civil cases, it contains useful legal arguments and principles that also apply in criminal cases. On this screen, we have a snapshot of page 2 of the sample notice of appearance. Here we have the assertion of rights language. Starting on the top, by and through counsel, the victim also formally asserts his or her rights pursuant to all applicable law. I want to pause for a moment and mention footnote 3. Footnote 3 is another note to practitioner, and it is intended to remind you that sometimes it is difficult to accurately anticipate all of the applicable rights in a particular case at the moment when you're filing a notice of appearance. So erring on the side of caution, it is good practice to not only identify the key authority that clearly apply, but also to add some kind of broad language that preserves the assertion of other potentially relevant rights down the road. On this particular example, we've accomplished this with the inclusion of the phrase, pursuant to all applicable law, including but not limited to the following rights under the Crime Victims' Rights Act. And then, as you can see on the rest of the page, we have identified in bullet form the other relevant rights provisions. And these are provisions from the Federal Crime Victims' Rights Act. And on this screen, I have a snapshot of the footnote 3 that I just mentioned, which is a note to remind you to have some kind of a broad language that will help preserve the assertion of other potentially relevant rights down the road. Finally, we want to alert you that many jurisdictions also have court-designed forms or agency-designed forms that crime victims may want to complete to preserve their rights to certain procedures or events. So for example, the form on this screen is an Oregon form that crime victims may submit to formally request certain rights, such as the right to be notified in advance of any critical stage of the case, the right to be notified in advance of release hearings, among others. So be sure to check to see if your jurisdiction has a relevant court form or agency-designed form, and you may want to file such a form concurrently with the notice of appearance. This brings us to the conclusion of this online toolkit video. Thank you for your attention. Please be sure to visit NCVLI's online toolkit library for additional resources.